Hello, welcome to this month's installment of our tax team webinar sponsored by Anderson Business Advisors. Tonight we're going to talk about real estate transactions and the reporting documents related to those transactions that are changing due to the Dodd-Frank Banking Act. What are the three documents? There's a HUD-1, there's a good faith estimate form, and there's a Truth in Lending Act disclosure. Those are the documents that we've been using as buyers and sellers when purchasing real property. Whether we purchase that real property for personal, our residence, maybe a vacation home, or we purchase that property as a rental property to be treated as trade or business property. All these documents usually come from our lenders, our escrow companies, our title companies. It depends on who we hire to help us prepare this documentation to represent the elements of the transaction between the buyer and seller. Well, the HUD-1 statement is traditionally your settlement statement. This is what lays out the cost that the buyer agrees to pay, lays out the cost the seller agrees to pay. It shows the selling price or purchase price. It shows a myriad of other items that might be prorations for taxes. It might be reserves that are paid by the borrower so that when the impounds, which is taxes and insurance, come due, that there is sufficient reserves paid by the borrower upon acquisition of the property to fund that. So all those items are the items I'm talking about in the settlement statement. But overall, what is a settlement statement? A settlement statement is basically a scorecard. Buying and selling real property is simply a negotiation. It's wheeling and dealing between a buyer and a seller. It's a scorecard. It represents the end or what the two parties want the transaction to look like. Prior to issuing the settlement statement, the buyer and seller have the opportunity to arm wrestle, wheel and deal, agree on terms, agree on which elements of the transaction are going to be paid by whom and to what level or what degree. So once we get done with the agreement and it gets submitted to the title company or escrow, this settlement statement, this HUD-1 statement, is the product that represents what both parties agree to. Again, it's a result of a negotiation. So how do we use this information in our everyday lives? Prior to coming to the table to sign a documentation for closing a sale or a purchase of real property, you have the ability to negotiate all these elements. That's the nice thing. By negotiating all these elements, we're able to determine, to the best of our abilities, what we are willing to agree to in acquiring or selling a piece of property. The good faith estimate form is a form that looks like a settlement statement, but it's just that, an estimate. As an estimate, it's designed to give you kind of a ballpark idea, or the parties, the seller and buyer, a ballpark idea, so that you can continue to hone the negotiation of the purchase or sale of the property that's of interest to both of you. The Truth in Lending Act disclosure, sometimes this is called a Reg Z. This document was necessary to try to express to a borrower, what is this loan going to cost you over the life of this note? Is it going to be just a principal and a stated interest rate, or is it going to compound? So a lot of times you're going to see large sums of money over 30 years paid for this piece of property in this disclosure. It might kind of surprise you. The new documents that we're going to talk about have been created to remove the inability to read these documents. The ones we're getting rid of, the ones we're saying goodbye to, the HUD-1, the good faith estimate, the Truth in Lending Act disclosure, all these documents had an element of confusion. What the regulatory agencies have come up with are much simpler and much more user-friendly, much more readable, and much more beneficial to most. But we're talking about it tonight because as of October 3rd, these forms here, the HUD-1, the Good Faith Estimate, the Truth in Lending Act statement, go away. So what are some of the major changes in real estate? Again, I talked about the Dodd-Frank Act. It's a congressional act that has been guiding the banking industry for a number of years now. And these new provisions, or these provisions that we're talking about, these new procedures, fall under or find their origin from this Dodd-Frank congressional act. There's an organization called the Consumer Financial Protection Bureau. This is who's going to oversee these forms. It used to be the Housing and Urban Development. That group is going away as far as managing these forms and all that comes from these, the complaints that might be issued, the amendments to these forms as time rolls on. The Consumer Financial Protection Bureau is charged with the responsibility of managing this area of real estate. The Real Estate Settlement Procedures Act is not going away. It is still being or guiding the use of these forms and the use of the information that we have to convey when we're buying or selling property. So there's still a relative entity or organization affecting the transfer of real property. HUD, Housing and Urban Development, on the other hand, who had as part of their responsibility the guidance and issuance of the HUD-1, the Good Faith Estimate, and that TILA, the Truth in Lending Act disclosure, all those had their origin in the HUD, and those are out. So those are gone. So again, out as of October 3rd are those first three disclosure statements that I talked about. The information in the two new ones are fairly the same information, very close to the same information that you have in these other three, except that when we get into these forms, you'll find they're laid out in a much more readable format. Now, my slides, when I get there, are going to be kind of small as far as the images, but I'll give you a website where you can go to pull down the actual forms in a demo format. And by reading that and studying it, you'll have a much better understanding of how user-friendly these new forms are going to be. So the new forms that we're talking about will be effective as of October 3rd. And again, the first one is the closing disclosure, or CD. The closing disclosure, or CD. That's about a 5-page document. In addition to that, you have a loan estimate form, or LE. These are the two replacement forms. They're better known as the know before you owe disclosures. In other words, these help you really understand the impact of the transaction you're getting involved with prior to actually signing and looking retroactively after you signed what happened. Some of us have had experiences where you close or read the settlement statement and the closing documentation at the signing table. When you read it at the signing table, you don't have much time to be able to refute or argue some of the items that might be listed in the settlement statement. If you're strong enough, you could tell the escrow officer or the lender or whoever it is assisting you with these forms that you're not going to sign until this representation matches what you expect it to be. But most taxpayers don't have that strength at the signing table. So within this new set of rules, there are some dates that are key to helping borrowers understand when they have to perform. So within the closing procedures, the new closing procedures, And looking at the closing disclosure, all these forms must be ready 3 days before closing. So if the borrower and buyer have, or borrower, sorry, buyer and the seller have submitted all their documentation to their representatives, which have made their way, those documents have made their way to the escrow officer or title company who's actually putting all this together. It's supposed to be an independent party. So anyway, the lender has to have all their information in no later than 3 days before the date of closing. The borrower, the buyer, the realtors, anybody and everybody involved in the transaction, there could be repair bills that might be purchased through escrow. So you may have contractors who have to submit their bids. There may be lenders that or loans that are being paid off, and those lenders have to have their payoff documents submitted prior to 3 days before closing. Otherwise, the closing date gets extended until all this documentation arrives. So as a target date, it's best that we plan for a week ahead of the date we're trying to choose for closing. If you're a buyer, a lot of times you like to close toward the end of the month due to some proration of interest on the loan that you're taking out to buy that piece of property. Because you're trying to close at the end of the month, we have to look back 7 to 10 days and urge those service personnel that are acting in our behalf to get their stuff ready so that the end of the month closing date is not in jeopardy and of being extended beyond the end of the month. So we get 3 days offered to buyers before the closing date to get all the documentation submitted. Now, if the buyer and seller decide to negotiate or make a change to the negotiation, that's going to reset this 3-day rule, and the 3 days starts over again. And we're talking about 3 business days. So if you close on, or the days start on a Friday, then Friday's a business day. Saturday and Sunday are not business days, but that's two more days. Then Monday and Tuesday would be the 2 final business days. So it could be 5 days out before the close takes place. And again, like I says here on the slide, buyers and sellers can cause delays in closing if at the final hour somebody decides to change some terms. And those terms have to be posted or expressed in the documentation leading up to closure. So here's one of the first forms that we're going to talk about. This is the closing disclosure form. The second form that we're going to talk about is going to be the loan estimate form. And just a little side note, the loan estimate form needs to be delivered to the buyer within 3 days of the contract being issued. So the first document that I was just talking about in the back slide here, the 3 days before closing, relates to the closing disclosure. That's the first of the 2 new forms. The second of the 2 new forms is the lending estimate, and that also has a 3-day business rule, and that is that when the application is submitted, this loan estimate needs to be provided to the borrower within 3 days of receiving the application for a loan. Now, as a buyer and a seller, you're not so worried about these dates and getting these forms because you have others acting on your behalf. You're purchasing the services of these others. But it's important for you to know the rules so that when you're out negotiating to buy a piece of property, you have this information in your mind that will help you decide on when to set a closing date, when to make an all-cash offer, when to buy a second residence or a vacation home. Maybe there's timing of funding that for a down payment that you got to manage. So there's a lot of little pieces here that this information will help you in building your real estate portfolio and or acquiring your residence or second residence. So we're looking at the first page of the 5 pages of the closing disclosure. It's a lot more user-friendly, more readable. My slide, unfortunately, doesn't show that. What I'm going to tell you is that back here in the, pardon me here, back here in the summary, at the very last bullet point, I have a website, www.consumerfinance.gov, www.consumerfinance.gov. This is where you go to find these new forms and the sample forms, and I do recommend you go and gain an awareness of these forms so that when they're presented to you, they're not foreign. You're not fumbling trying to understand what you need to do. You can ask educated questions about what's on those forms because you're familiar with the basics of these forms by reading in advance. But let me go back to that first page. Okay. So in looking at this, we have at the top a header information, and it's good information, but it's laid out much cleaner than the settlement statement or HUD-1 statement, excuse me, that we're currently using. The nice thing is this thing clearly lays out in sections with those bold titles on the left-hand side, the loan terms, then there's a second section reported as the projected payments, and then the bottom section says costs at closing. This is kind of neat because the loan terms clearly state what you're borrowing, what the interest rate is going to be that you're going to owe, what your monthly principal and interest payment is going to be. But there's two other things here that are very nicely laid out that are usually fairly difficult to find. On the right-hand side, there's a question at the top that says, can this amount increase after closing? We're talking about the loan terms. Can they change after you sign the closing documents? This declaration says, no, they can't change. So you can't be duped into buying a variable rate loan or adjustable rate loan when you thought you were buying a fixed rate loan. The second question down here says, does the loan have these features? And the features they're asking about are over on the left. Can you prepay the loan subject to a penalty or not subject to a penalty? Sometimes lenders want to wait and have you service the loan for a period of time before they will allow you to pay it off because it costs them a certain amount of money to extend the loan to you. They want to recoup those costs by holding the loan out for a period of time. Will you incur a prepayment penalty? Yes, in our example here it says no. Sometimes it says yes. Sometimes it says yes if you prepay the loan in as little as 5 years. Sometimes it's yes if you prepay the loan in 2 years. So it all depends on the terms of the note. Secondly, it wants to know, is there a balloon payment feature to your loan? These are all parts of things that are negotiated prior to the settlement table, prior to looking at the closing disclosure. But it's nice to see how easy it's laid out. You're not fishing through 40, 50, 100 pages trying to find this information. The second area says projected payments. It gives you an idea in years 1 through 4 and years 5 through 30 on the 30-year note, excuse me, what your expected principal interest payments are going to be. And you can see that in our example, for years 1 through 4, the principal interest payment of $737.91 matches that disclosure up in the first section. In years 5 through 30, it's the same number as that disclosure in the first section and in the first 4 years. There's no change there because that question that says, can this amount increase after closing, is no. If that amount is yes, these numbers down here in this projected payment section will be different based on what the changes might be from the agreed upon features of the note that you signed. Are you going to have mortgage insurance? What is mortgage insurance? In this case, we have mortgage insurance through the first 4 years, but nothing in years 5 through 30. Typically, mortgage insurance is an insurance policy that the lender asks for to mitigate or reduce the risk of extending you a loan as a borrower to buy the property you bought. This insurance pays the lender should you default and not pay the note. So if the loan goes into default, the mortgage insurance that you've been paying as part of your monthly payment pays out a premium, a proceed to the lender to cover the cost or the burden of having to take this property back or foreclose on a property because you're not servicing the note. That's what mortgage insurance does. The estimated escrow impounds, these are payments that lenders like to have the borrower prepay throughout the year. Depending on where you live, what state you live in, you have real estate taxes that need to be paid. The lender wants to control the payment of those real estate taxes, so they use the impounds or the escrow collections that they collect monthly in the monthly payment to be able to fund those real estate taxes on your behalf. Now, here in Nevada, we pay our real estate taxes quarterly. In the state of California, you pay your annual real estate taxes in 2 installments. In the state of Oregon, you can pay it annually, or you can opt to make 2-month or 3-month payments to remit your taxes. Utah is a single payment once a year. So depending on the state you're living in will depend on the frequency at which the lender has to cut a check on your behalf for the real estate taxes related to your property. The lender collects that money from you as a component of your monthly mortgage payment, saves it in this escrow or impound account, and then remits the money to the taxing authority when it's time to cut the check. Also in the estimated taxes or the escrow or impound account is a collection or component for insurance. Insurance could be $800 a year, $1,200 a year, depending on the size of the property, depending on the if you're in a flood zone. It could be a myriad of factors. So when you acquire an insurance policy for the property, that insurance policy is usually divided up into monthly payments. Again, that is collected through your mortgage payment that you pay once a month to the lender. And then once a year, typically, the lender will cut an insurance check to renew the insurance policy. You're prepaying, they're holding it as like a pseudo savings account, and then they're remitting the funds on your behalf when it's time to pay the insurance. These are called impounds, escrow funds. Sometimes you'll see that upon closing, the lender is going to require the borrower to have a certain amount set aside as reserves initially. They may ask you to put 2 months, 3 months, 6 months reserves into these impound or escrow accounts as part of the closing statement, the closing disclosure, so that when it comes time to remit the taxes or comes time to remit the insurance, sufficient funds have been collected from the borrower and placed in those escrow accounts. Upon sale of a piece of property, the surplus money that's sitting in these escrow accounts is usually refunded to the borrower based on the date of the sale contract to the new buyer. So the last category down here on page 1 is costs at closing. It gives us a clear picture of what it costs to perform or conduct the services to close this transaction, selling the property from the seller to the buyer. It says cash to close. In this example, the borrower has to come up with, if you look down here at that X in the very bottom, has to come up with nearly $30,000 to close this transaction. This is the kind of information that is very important to the parties involved in the transaction, and it's a lot cleaner. It's much better presented in this format than in past formats. Now let's take a look at the second page. The second page of the new form, the closing disclosure, basically has 2 sections. The first section is the loan costs. What does it cost to acquire a loan from a lender? This information is extremely important to us tax accountants because it helps us understand what we're supposed to do with this when we're filing the tax returns of our clients. Loan origination charges, most people know, is the cost of acquiring a note. It's the cost that the lender is going to charge. Well, depending on how this property is going to be used, if it's a personal residence, a vacation home, these charges are going to be treated differently for tax purposes. If it's a rental property, a trade or business property, again, these charges are going to be treated differently. So we have to know the purpose of the acquisition of the property to know how to treat these groupings of costs. Then the nice thing here is something that we haven't seen in the past. The next two sections say there's services that the borrower did not shop for. Then there's services that the borrower did shop for. So you have the ability sometimes to go outside the escrow office or lender and not use their vendors, not use their resources. The closing disclosure, this new set of closing procedures, gives borrowers an opportunity to come to the closing table with an alternative source providing services that may be cheaper. It may have a better reputation, but it allows the borrower to have a say in who's conducting some of the business on behalf of the lender and those involved in transferring the property. The next section says other costs. Again, the layout of this new form is what I'm speaking to. All this information is in the existing forms we've been using for years. It's in the settlement statement called the HUD-1. It's in the Truth in Lending Act statement, but you got to farm it out. You got to find a way to dig it up. This is laid out in a very clear, concise way, and from my first blush, it's going to be very helpful to borrowers, buyers, and those of us that are users of this information on behalf of the borrowers and buyers in these transactions. So I behoove you to actually go through these new forms, take a look at them, become familiar with them, see if you can leverage these sections to your best benefit when you're trying to determine how to present an offer if you're a buyer, or you're trying to determine how to present a counter offer if you're a seller. Page 3 talks about payoffs and payments. This is important because it lists who are the current lenders or who are the current lien holders related to a property that is proposed for sale. Here you can see clearly all those that may have a claim to the sale proceeds of that house should it transfer. Calculating cash to close. Again, this is a little summary section at the bottom of page 3 that really helps lay out the use of funds. Now, there's a couple other pages with the closing disclosure that are new, but they help you see is a loan assumable? In this case, it's not assumable. Is there a demand feature? So there's a lot of little X's that you can go through as a real estate investor and kind of look at to see the things that you might try to negotiate to create leverage in the real estate transaction based on some of the information that is being disclosed in this disclosure document. The next document, the second of the two new forms, is called the loan estimate. I'm sorry. This is the page 3 of the closing disclosure. This is where all those that have claims or liens, the mortgage companies, anybody that might have done work that hasn't received payment, this is where they're going to have their names listed. This is page 4. I'm sorry. This is the new loan estimate. I did not copy those two other disclosure pages. Again, go to that website that I mentioned. I'll mention it again here pretty soon. Go to that website, familiarize yourselves with these forms. If you're going to be involved in a real estate transaction anytime soon, or you're regularly involved in real estate transactions, these are the tools of the trade. It's important for you to know how to use these tools to maximize the benefit you can derive from these. All right, now this is the loan estimate. It's basically a replacement of the Truth in Lending Act disclosure. It's a lot of duplicated information that we saw in the closing disclosure, but it's related primarily to the loan. I won't go through this as closely as I did with the first document because it's duplicative. As you can see here in the loan terms, there's the questions: can this amount increase after closing, with a bunch of no's? Does this loan have these features: prepayment or balloon payment? Duplication of prior, but very important when you're trying to negotiate the sale or purchase of real property. Again, duplicated is the projected payments. Now again, this document is an estimate. It was issued 3 days after receiving the initial contract or agreement between the buyer and seller, long before we get to the end of the period of which we're trying to close on the sale of this house. So this is an initial document, and then the closing disclosure is what you find at the end of the process when you go to actually sign the loan docs and sit down and sign the transfer of the property documentation. One of the things I like about this one is here on this second page. Again, it shows what the estimated loan costs are going to be. It shows in the second column under other costs what your taxes and other government fees should be, recording fees and whatnot. Then it says these prepaids, item F, and it has initial escrow payment at closing, item G. How do we treat these items? Well, those items are treated based on the purpose of the property. Is it a residence? Is it a second home? Is it a rental property? Is it trade or business property? Is it commercial property, not residential? All these kinds of classifications of real estate will dictate different use of this information by the borrower and by the seller. Again, here in this estimate of closing costs, in the left-hand column in the second and third sections, we have services you cannot shop for, and we have services you can shop for. If I recall, we go back to the other form, the closing disclosure, and bear with me as I kind of flip back to that page. At the end of the process, and I'll tab up for just a minute. Oh, take it back, come back down one more. Here in item B and C in the first section under loan costs, the header reads services borrower did not shop for, past tense. Services borrower did shop for, past tense. In the loan estimate document, which is received on the front end of the transaction on page 2, and I'll go back down there again, page 2. Items B and C in the left-hand column read services you cannot shop for and services you can shop for. The language changed a little bit, so it shows you what you can do, what you can't do. The lender is requiring in this example that you utilize the appraisal fee and credit report fee charged by people, probably the lender, and they won't allow those you to substitute those fees from another source. This is very good information as well, because in past transactions, if you weren't creative enough to ask, can I do? Can I have? If you just went along with what your realtor or the broker or your representation, maybe your real estate attorney, was guiding you by and not disclosing to you what your options are, you may not be aware you have some choices. I like these documents because they clearly express that you have some choices and the ability to negotiate some of these elements to close. And I can just tell you, I personally sold a home here about 6 months ago. And preparing to sell that house, I negotiated an agreed upon fee for as closing costs. And then I negotiated with the buyer back and forth several times until we got to the point where we felt we could do no more to better the agreement between the two of us. I, as a seller, though, felt I was still overpaying. I was paying too much for services. So I went back to the service providers, my realtor, the buyer's realtor, the lender, the title company, the escrow company, and I asked everybody to kick in a little, reduce their fees that they were estimating they were going to charge. I asked for a reduction of their fee structure and got quite a bit of that money back. So if you don't ask, you may not know that those elements are negotiable. I was taught years ago that everything in a real estate transaction is negotiable. Sometimes the lender will dig their heels in and say, nope, I'm not doing anything. Sometimes the escrow company says, this is a flat fee, this is what we charge. We can't reduce our fees. But you have power as the seller. You can dig in your heels and say, well, maybe I need to use somebody else. Maybe I'll take this transaction to somebody else so they can earn the money that I was willing to pay you. That power allows you to negotiate the best terms possible for the transaction if you're selling or buying in a real estate transaction. So, in summary, all real estate closings in the very near future are going to use these new forms. As of October 3rd, I was going to teach tonight on a whole different concept related to these settlement statements and negotiation opportunities, and I will table that for a later date. But when I realized that this October 3rd date was approaching quickly, I felt it was prudent to take this time to introduce these new forms and this new process to anybody involved in real estate, whether you're doing it, again, buying your first residence or your primary residence, where you're buying a vacation home, whether you're buying investment property. It's important to know that these tools will help you maybe negotiate a stronger position in your transaction. The closing disclosures and the loan estimate forms replace the existing HUD-1, the Good Faith Estimate Form, and the Truth in Lending Act, or TILA form. Those are going to disappear. Apparently, borrowers, when we had our real estate meltdown of 5 or 6 years ago, were complaining. The large amount of foreclosures were complaining. The borrowers were complaining that they couldn't understand these documents. They didn't understand what they were getting into. Well, I think the real estate industry has done a marvelous job at removing some of those unreadable documents and putting them in a format that is clearly expressing the components of real estate transaction. The third item is buyers and sellers should have all escrow, should have all their documentation to their escrow 1 week before closing as a best practice. The rule is 3 days, but if you have everything in 7 days ahead, then you got time to congel it, get ready. You're not rushing. Nothing gets dropped. The 3-day closing date doesn't get extended because something was forgotten. Try to get everybody involved in your transaction to honor the 7-day rule, just because it gives you enough time to react if a change has to be made, a correction has to be provided prior to the 3-day rule being invoked. Again, familiarize yourself with the new forms at www.consumerfinance.gov. This is the website of that organization that I mentioned in the beginning, the Consumer Financial Protection Bureau. This is where you're going to find lots of documentation. In fact, when I reviewed that website, I saw there was many invitations to sit in on other webinars to teach the actual use of these forms. If you want that opportunity, there's going to be several opportunities to reach out and be involved in a presentation regarding these forms. We at Anderson Business Advisors, thank you for attending this session of our tax team webinar. And we look forward to working with you in the very near future. Have a great night.